Like Corey mentioned, my name is Donna Barkho, one of the attorneys with the Barkho Law Firm. I guess before we jump into today's Estate Planning 101, just a little background about myself. I founded the Barkho Law Firm with my sister Dahlia, who's also an attorney. On the brink of COVID, we were both working with other law firms, and just so happened that things happened during COVID. We were laid off from our jobs, and we thought, hey, let's open our own firm. Let's do things our own way, which we're really excited about because for both of us, our main passion is helping families. So we are able to kind of cater to families in our community in the way that we would like to. So we're really excited about that. I am married with a little one on the way, which is really exciting. It's our first child, so it's a little nerve-wracking, but also very exciting. A little bit more about me is I enjoy sketching, baking and cooking, and just spending as much time as I can with family and friends. So just a little bit about me. So before we jump in to the nitty-gritty of estate planning, I just wanted to kind of point out a few questions that we see very often from families that we meet, from just the community in general, things you might see that pop up online. And just as a little disclosure, not everything you see or read online is true. I just want to let you know, sometimes you'll hear things from family or friends, things that worked for them or things that they were told that may or may not be true, that may or may not work for you. So always consult with your attorney, always do your research, make sure you are educating yourselves before you jump into any kind of estate planning. So a lot of what we hear, some main questions what we hear is, what is a power of attorney? What are they? How do they help me? How do they work? Things like, what is probate? What is probate court? Why is everyone trying to avoid probate court? What's a will? What's a trust? What does estate planning cost? And do I even need to have an estate plan? So throughout the conversation today, we'll go through all of these questions and then some. Like Corey mentioned, feel free to throw in any questions you have. I'd be happy to ask them. And you don't have to wait till the end. Feel free to throw them in as we're kind of going along, and I'll try to catch them. All right. So I will begin with what sometimes is known as pretty simple documents. They're simple in their description, but they're very, very powerful in what they do. And those are powers of attorney. So powers of attorney cover you for incapacity planning. This is that scenario of I'm still alive, but I'm unable to do things for myself financially, legally, maybe even with healthcare and medical decisions. What happens in that scenario if I'm, let's say I'm in a coma or I'm out of the country or for some reason I'm unable to act for myself? Without documents in place, my loved ones would have to go to court to seek guardianship for them to be able to access my banks, to sign things on my behalf, to do anything that they may need to do legally or financially on my behalf. That's where powers of attorney come into play. These documents allow me to, or anyone drafting them, to be able to name the person or people that they want to be able to step in their shoes and help them make those decisions, sign off on those documents, do things for them should they be unable to do so for themselves. A reason we would want to avoid court in this scenario is it could be costly. It could be time consuming. If you need to do something right away, a judge wouldn't be able to see you that same day. It's usually scheduled weeks out. And sometimes it's not the person that you would want to be put in that position. So having these documents into place allow you to choose who you want. So there's two types. Like I mentioned, there's a financial and there's a healthcare. A financial power of attorney covers you from anything A to Z with legal and financial affairs. That's banking, real estate, sometimes even dealing with estate plans. I mean, the list goes on and on of what you would want them to have powers to do. The way we draft our documents is we go through one by one. You get to choose what you would want them to have the power to do. You're able to have them be able to do things for you right away, or you could do what's called a springing power of attorney, excuse me, which doesn't come into play until there is some kind of incapacity. Now, for that to come into play, you would need 2 doctors licensed in the state of Michigan to be able to sign off to say that you are indeed incapacitated and now you need someone to step in your shoes. Most families don't opt for that just because of the ease of, having their agent or the person they choose to help them with things. Usually we just want them to help us whenever they need to. A couple things some big misconceptions that we do see in the community, or that people often ask us, is if I'm married, can't my husband or wife just automatically sign things for me or go to the bank for me? And the answer is no, unfortunately. If your husband or wife or your spouse is not listed as an owner of a certain account or on your home or whatever asset or whatever thing you're trying to do, they won't have the ability to sign off or make decisions on that asset or that financial affair or legal affair for you. Having a power of attorney allows you to control everything. So, for instance, if I have one drafted for myself, I could name my sister Dahlia to be my power of attorney. Should she be unable to act for any reason, I could name multiple people beyond her to step in that role, just to kind of have a buffer, to have a few people listed in case someone can't act or is not willing to at that time. One thing I do want to mention as well is powers of attorney only work while you're alive. So when somebody passes away, powers of attorney no longer work, and this is when we would want to look to your will or your trust to see how now to distribute your assets. So powers of attorney only cover you for having someone step in and help you make decisions and do things for you legally and financially. Which takes us over to healthcare. So like I mentioned, a healthcare power of attorney works very similar like a financial. You'll hear it called different things. Michigan calls it a healthcare power of attorney. Sometimes you'll hear it called a healthcare proxy. So this document here allows you, again, to choose the person or people to step in your shoes. You get full control of who is your agent. But here, what they're accessing is medical records, helping you make medical decisions. They're able to talk to your doctors and work with them in making those decisions. Our healthcare powers of attorney are very extensive. They cover you for the healthcare, like the physical part of everything, but they also cover for some mental health care as well. So if there's any kind of healthcare issue going on where you're unable to make decisions for yourself, your healthcare agent will be able to follow what your healthcare power of attorney says, work with your doctors to make sure you get the kind of care that you wanted. There is the DNRs, the do not resuscitate provisions that you often see with hospitals. Those are worked into healthcare powers of attorney as well. So it's you are able to choose, what kind of care you would want when it does come to end of life decisions. Things like, do I want a feeding tube? Do I want, tube nutrition? Do I want CPR? Do I want certain things to occur if I am truly at the end of life stage? So you get to mark all those down on your power of attorney. And then it becomes your agent's job to make sure that that's all carried out in the hospital with your doctors. So like I said, very straightforward documents, but very powerful in what they do because they are giving control to someone other than yourself. The one thing I want to mention with healthcare powers of attorney is if you are able to, you're always the one making those decisions. Healthcare powers of attorney only come into play when you are incapacitated and are unable to make a decision for yourself. That's when your agents would step in and help you out. Next, we could jump into wills. So what is a will? And do I need one? Who needs one? So a will is a document that helps you coordinate the distribution of your assets after you pass away. So you own everything as you do today, but it's when I pass away, who's getting my stuff? Who's getting my house, my bank accounts, the stuff in my house, my furniture? It covers for all of it. So there's two big things. I'll backtrack a little bit. I'm sorry. There's two major reasons why we want to have a will drafted. One is for that distribution of your assets, to name who gets what. The second one, which is also very important, is to name guardians for any minor children. So you're able to choose in kind of in layers. So who will get guardianship of my minor children, and what if they're unable to act at the time, or what if they're not around to be a guardian for my minor children? We're able to name levels of people just to make sure you're covered there. A big thing with wills, many people feel like if I have a will drafted, I'm set. I don't need to worry about anything. When I pass away, everything I wrote in my will should occur and will occur. And sadly, that's not always true, because wills have to go through probate court. Probate court, every county has a probate court that deals with people's estates. So things like someone's will, guardianship, conservatorship. So when someone's will goes through probate court, it could go as you wanted. Things could get distributed just like you wrote, or it can go kind of sideways, meaning, a spouse can ask the judge to throw the will out and follow a certain formula that the state sets to what they get. A will can be easily contested. Going through probate court makes your will public now, so it's a part of public record. So anyone receiving a distribution knows what each sibling got, or everything becomes kind of common knowledge for everyone. Probate court can be pretty costly. Sometimes it could cost anywhere between 5 to 10% of the value of everything that's going through probate court. So if you have a house that's worth $300,000-$400,000, a big chunk of that could go towards the fees that you have to pay, inventory fees, filing fees, and not to mention the time. The average time someone spends taking someone's will to probate court can last anywhere from 12 to 18 months. So when someone passes away, it's not as easy as taking care of their affairs right away. It could take, a year, maybe 2 years to kind of wrap up everything. And people just want to avoid that, and I don't blame them. It's kind of a tedious, long process. If you guys have any questions on anything I've talked about so far, go ahead and throw them in the question and answers, and I'll be sure to keep an eye out for that. All right, so a trust. So a trust is very similar to a will, but it's more nuanced. It's more detailed. A really big, probably the main difference between a will and a trust is that a trust does not go through probate court. A will has to go through that process. A trust does not, unless there's an issue with it, or unless someone's suing it or something of that sort. But for the most part, trusts do not go through probate courts. And that's really the big advantage of having a trust over a will, is you could pretty much bank on what you've written will occur. Trusts, in my opinion, have a little leg up over a will because you get more planning flexibility. So you're able to name who receives your assets. Let's say I have 3 children and I want all 3 of them to receive things equally from my trust. I could go forth and say, if something were to happen to each one of those kids, what would happen to their share, to their third? Does it go to their kids if they have any? Does it go to their spouse? Would it go to a charity or someone else I choose? I can name layers of beneficiaries to make sure that someone's getting something, so that way the money doesn't fall back to the state. Someone who I choose will receive the inheritance from my estate. I mentioned that trusts avoid probate court completely, so it means they stay private. Nobody needs to know anything that's part of your trust except for your trustee. So your trustee is the person you name to kind of make distributions for you, to manage things once you're unable to do so for yourself. So, when you get your will drafted and signed, you and your spouse, or you alone, would be the trustee of your trust. You own everything that's part of it. You can access everything that's part of it. It's yours. until you pass away, and then the person you name to be your trustee steps in and starts following all the directions that you've written in your trust. The planning flexibility really goes pretty deep, and it's something that we will talk about together if we work together in getting a trust or any kind of estate planning drafted. But it's great because you get to name the beneficiaries, you get to list what ages they receive their inheritance. We take it so far to say, what if everybody I've named in my document in this trust is not around to receive a distribution? Now where do things go? Who's going to get my money and my stuff if there's nobody around that I've named? We list someone, whether it's a charity, whether it's just your next blood living relatives. We want to make sure someone is named so things don't revert back to the state of Michigan. You work hard for your money. We want that money to go to those people that you want it to go to, for sure. A great advantage of a living trust is that it gives a little bit of asset protection to your beneficiaries. So let's go back to that scenario of I've left things equally to my 3 children. Let's say one of them is going through something like a bankruptcy, maybe a lawsuit, maybe something like a divorce at the time that they are to receive a distribution from my trust. If they're going through something like that, we can opt to hold their distribution in the trust until they clear up what's going on in their life, so that way they don't lose that inheritance to the divorce or to that lawsuit or to the bankruptcy. So it provides them a little bit of asset protection for their inheritance, which I think is great, which they would not get with a will. When the time comes for a distribution from a will, they get it right away, regardless of what's going on in their life. So they could potentially lose that inheritance if there is something financially catastrophic going on at that time. So the reason revocable living trusts avoid probate, the reason they don't go through probate court, is because after you sign your document, we have to do something called funding. Funding a trust is a very simple process. It may sound kind of complicated, but I promise it's pretty easy. It's a matter of naming your assets to be held under your trust name versus your individual name. So if I were to fund my trust, let's say I have a trust drafted, it's called the Donna Barkho Family Trust or the Barkho Family Trust, and I want to put my assets in there. So I would go to my bank, let them know I want my checking and savings account to be named under my trust name versus my individual name. And that is kind of the process of funding. Takes it out of your individual name, puts it in your trust name. Now it's tied to the trust. Now it doesn't go through court. Now it follows whatever you've written in your trust. You want to do that for pretty much every asset you have. Again, it kind of goes on a case-by-case basis. So, we would talk through during a meeting what assets should and should not go into your trust, but we pretty much want all assets in there. Things like your home. The way we take care of your home is through what we call a ladybird deed. So this is a style of quitclaim deed, which is probably what you have if you own your own home. But we changed it up a little bit. We keep the house in your name like it is today, and we add and build in some language in there that states, you own your home today, but if something should happen, now we want your house to go into your trust, and your trust will dictate who gets it, whether it's the kids or whether it's a family member or friend. So that way it keeps it from going to probate courts. And that goes for any asset. If you have retirement accounts, things like a 401k, an IRA, life insurance, for certain assets like those, we can't change the name. They have to be held by you as an individual person. But for those, we want to list them as we want to list the trust as a beneficiary. So that way, again, if something were to happen to you, that retirement account or life insurance goes into your trust and then to your beneficiaries. Pretty simple. It's something that we'll talk through as we go through. Once you get your documents signed, we would make sure that you get, we can work with your financial advisors, kind of get things put into your trust properly. It's very important that your trust is funded. If we were to sign a trust today and you never change your assets to be a part of that trust, you pretty much have an empty trust, and all your assets will end up going to probate court because they're still held by you individually. So it's probably the most important part after signing your trust to go ahead and retitle things to be a part of it, just to ensure nothing goes to probate court. A couple things I wanted to point out, we get asked this a lot, I get asked it almost weekly, is what if I just name my kids as owners on my assets? Like if I put, my son or my daughter as a owner on my checking account or on the house. And I always advise against this unless there is a big need or a big reason, or unless you truly are sharing a bank account. You don't want to just list the kids or, family members or friends as a joint owner on your assets for a number of reasons. The biggest one is for liability issues. If I were to name, let's say I have an 18-year-old son and I name him as a joint owner on my checking and my savings account. If he is involved in a car accident and is being sued, if he's involved in a divorce, if he's being involved in a bankruptcy, any of his liabilities, my checking account is now open. It's on the table to that because he's a joint owner on there. So if someone's sole reason is, hey, let me put my child as a joint owner on an account, I would say not to, for the sole reason of it being passed to them at your passing. There's other ways to do it, safer ways to do it to protect your money. Same goes for beneficiary designations, somewhat. So a beneficiary designation is, sometimes it's called different things at different banks. Sometimes they call it a payable on death or a person to name for a transfer on death, which is essentially with your bank, you could list someone that would receive your account should you pass away. I guess the caveat here would be you're not giving asset protection to your beneficiaries. You're not able to kind of list what ages they receive things. I mean, they would just get it right away, regardless of age, regardless of what's going on in their life. And for some cases that works, for others it doesn't. If you have a 18-year-old child and you have a huge savings account with $100,000 sitting in it, it's kind of brings up the question, do you want your 18-year-old to receive this windfall of money all at once with no supervision? Answer is probably no. I guess a fun fact for you guys is the average inheritance, regardless of how much someone receives, the average inheritance is usually spent within 18 months of someone receiving it. So if a large inheritance is being left to someone who's young or someone who just wants to buy a new Corvette or go shopping, it's probably not the best idea to give them this windfall of money all at once. Okay, so kind of going to jump into who is estate planning for. So growing up, I think I also had the mindset that falls under this misconceptions is estate planning is for someone who has a lot of money or someone who has lots of properties and businesses. Thinking estate planning is for someone who's sick and who's kind of planning for, the time that comes if they were to pass away, or someone with a big family or a senior citizen. And I kind of want to debunk some of that for you guys, because estate planning really is for, in my opinion, everyone over the age of 18 years old. A little example I have for that is, if you have an 18-year-old who is going off to college, let's say they're going off. This is actually a true story of a client I had. Son or daughter, it was actually their son, was off to college. Mom and dad were paying for their tuition. So they tried calling the school because they had some questions regarding payments or something of that sort. School would not talk to them at all because their son was 18 years old and they wanted to talk to the son. Parents are like, well, we're paying for it. Can you guys talk to us? Nope, because he's 18 years old, he's legally an adult. So we need his permission. before we could talk to you. And that goes for anything. That goes for medical decisions. If an 18-year-old ends up in the hospital or a doctor's office, you don't automatically get to go in there and make decisions. Anything financially or legally, just, I know they're your babies and we think of them as being our babies forever, but once they hit 18 years old, you really don't have any control, which is not a great thing, because at 18 years old, most kids still need their parents to help them, especially if it is a medical emergency. I think anyone over the age of 18 should have at least powers of attorney, just in case there is some kind of emergency, which kind of takes me into someone who's single with no family and no kids. It becomes even more important now to name somebody to be at least your power of attorney, just in case there is an emergency. Again, someone to make medical decisions for you, to help you out with anything legally or financially that may come up. A big thing I always say is, it doesn't matter how much money someone has, how much you have saved up. It doesn't matter how much your home is worth. If you have any kind of asset, it's something that you've worked hard for. You don't want it to have to go through probate court. You don't want to lose any of that value or that time. Get estate planning done. At the very least, meet with an attorney to talk about your options. Trust planning is not always for everyone. Sometimes a will is really the way to go for someone. Sometimes you meet with someone and really powers of attorney are all they need. They don't need much more than that. Every family and every individual is different. So one thing I don't want you guys to do is talk to your family members or your neighbors and, get a trust just because they got one, or get powers of attorney just because they got one. Really meet with an estate planning attorney, talk through your options. Hopefully after today, you guys have a little more, education on estate planning, so it gives you an idea of what might work for you. But definitely talk it through with an attorney. Makes it a lot easier. Helps you make a good decision on what works for you and what may not. And I guess that takes me into the last one about privacy and probate avoidance, which was kind of a big one today. Probate court avoidance is huge. Many families don't want their assets going through probate court just because of the fees. Things becoming public, like I mentioned, it's just something that they would much rather avoid. I know I would. All right, I kind of ran through things. Does anyone have any questions? It looks like we might have a couple questions here. So one I got is, when a husband and wife have a trust where both were trustees equally, the husband has passed, do you need to amend the trust? That's a very good question. Usually no amendment needs to happen. If the trust was drawn as joint, so if the trust was made for you and your husband equally, you are both trustees on the trust, I would say usually we would have to look into the trust, but usually if one trustee were to pass away, the other trustee now has full authority with the trust. And then it's usual that when both trustees pass away, now it goes to the successor trustee. So changes don't necessarily have to be made. I will suggest having it reviewed. I know our office does free reviews of estate planning just to make sure everything else is into play. Kind of takes me into a point of, during any big life change, whether it's someone's passing, whether it's someone getting married, having children, any big changes in life, you do kind of want to revisit your trust to make sure it's up to date with your goals and what you want to occur. But for the sole reason of this question, where you were trustees equally, you don't need to make that amendment. But I still kind of recommend you reading through your trust to make sure it is still doing what you want it to do. Next question I have is, I hear that you should put everything in a trust, your home, your life insurance, your IRAs, checking and savings account, your annuities for tax benefits. And I would say, yes, we kind of covered that a little bit. You do want everything in your trust. And like I mentioned, and I can't stress this enough, it is the most important part of your trust once you sign it. Again, if you don't put your assets into your trust, you just have this empty shell that will still go through probate court and it's going to still go through all the fees and publicity and all of that. So making sure everything is put into your trust properly is very, very key. It's very rarely will there be a reason not to put something into your trust. Again, if you have a financial advisor or if you are working with a financial advisor, and if you're open to it, we always keep them in the loop of what we're doing, just to make sure for tax reasons we're doing things properly. But you don't file taxes for your trust while you're alive. Everything stays the same. You still own all your assets the same, even after you transfer them into your trust. You could still access them just like you do today. You could still use your debit card. Nothing changes. You fully own them. It's just at passing, now we know what to do with them, and we're able to make those distributions to your beneficiaries. Next question I have is, how do I put my house in my trust? This was also something we touched on very briefly through that ladybird deed. The best way to get your house in your trust is to deed it into the trust. And it's a fairly simple process that we would help you with. It's just, like I said, drafting that deed to say, I own my home right now. I could still sell it. I could rent it out. I could do whatever I want with it, just like I can today. But at my passing, I want my house to go into my trust. Another thing I want to mention really briefly on the whole house situation is some families ask, can I just deed it to my children? Like, what if I sign a deed today that says, I'm deeding my house to my sister Dahlia. I sign it, I date it, and I put it away in my safe, and I tell my sister, if I pass away, take this deed to the Register of Deeds and record it with the county, and the house is yours. That could work in certain situations. You could sign it 10 years in advance and have someone record it after you pass away. But now you're kind of taking the risk of the Register of Deeds rejecting that deed for whatever reason. I have found the Register of Deeds to be very finicky. They want things to be perfect. If for any reason they reject it and they tell you, take your deed back, fix this issue, sign it again, and then try to record it. Well, what happens when the owner of the home has passed away? Now this deed has to go through probate court. So it's not the best way to do it. The best way to do it is through a ladybird deed into your trust. So that really ensures safely in there. It's avoiding probate court. And we record it right away. So we don't wait till someone passes away to record it. A question just came through to explain ladybird deeds better. So I hope my explanation helped a little bit. A ladybird deed is a style of quitclaim deed where you still own your home today the way you do, just puts it into your trust at your passing. Next so I have another one about how do I deed a house to the trust. I really hope I answered your questions properly on that one. It seems like to be a big one, and it is a big one. For most families, for most people, your home is your biggest asset. It's your most valuable asset usually. It's very important to have it in your trust. If you have a trust right now and your home is not in it, make sure you work with someone. You can call us, you can call someone to help you draft a proper deed, have it recorded with the county to make sure it's in your trust. If you're questioning, you're not sure whether it's in your trust or not, if you currently have a trust, again, you're welcome to reach out to me. We can look into it to make sure it's done properly for you. Next question we have is there a difference between irrevocable and revocable trusts? Yes, there is. So we didn't really touch much on irrevocable trusts. Most families find that revocable living trusts work well for them. So we talked about the revocable living trust. An irrevocable trust is a trust where you still own the assets that go into it, but your trust is irrevocable, meaning you kind of give up a little bit of control of your assets to your trustee, which is yourself. So you're not really giving up much there. But irrevocable trusts are usually used when someone's trying to get some kind of asset protection, whether they are trying to be protected from lawsuits and creditors. Most of the time, families look towards irrevocable trusts, so that way they can kind of prepare for whether or not they'll ever need nursing home care. So I could touch on that a little bit. I don't want to give you guys too much so it doesn't get a little confusing, but with nursing home care, if someone meets this standard where they now can apply for Medicaid to pay for their nursing home coverage, Medicaid won't really cover you if you have a ton of money in the bank, and there's certain dollar amounts for individuals and certain dollar amounts for a married couple that if you pass that threshold, they won't pay for nursing home care. So these irrevocable or these asset protection trusts allow you to put your assets in this protection trust where it takes it out of your name completely, and it's drafted in a way where it really separates you from your trust. So now you're able to get on Medicaid, let's say. They know about this trust, but because it's not in your name, it's held in this protection trust, you're able to qualify for certain coverage there. Sometimes it works for certain business owners. Again, it really depends on what your goals are in estate planning. And that is something that if you do decide to meet with us, that we'll discuss which type of trust works best for you. I would say from what I've seen, 75% of the time, a revocable living trust is the way to go for most families. Again, we have to talk about what your goals are, talk about your situation and your assets. Let's see, I covered the house questions. It looks like that is all the questions that have come through. I think that kind of covers everything for today that I have for you guys. I hope it was very helpful. I hope you guys got a little bit of information. Again, I just want to point out, make sure if you do any kind of Googling or any kind of online research, a lot of what I see online is not in fact true, or it's for other states. A lot of things are state specific. So make sure you do your due diligence. Give our office a call if you have any questions. We do offer free consultations, free meetings. So I'd be happy to meet with you, in person. We can have a chat over the phone. We do a lot of Zoom meetings. We do in-home visits as well if someone's unable to meet us at the office. So give us a call, check out our website. Thank you guys for your time today. I really appreciate it. I hope you guys found this very useful. I'll leave this up for a minute just so you guys can see them.
I'm just going to echo Donna and say thank you so much for joining us. This was a recorded presentation, so if you have any questions or you'd like to watch it again, we can absolutely reach out to you and send that to you via email. Thank you again for registering. Please contact Donna or her sister. Her sister Dahlia does personal injury, and they are both exceptionally patient. Personally, I used Donna for our complete estate planning package. My husband and I had a lot of questions for her. They were very, very patient. I worked with her sister as well. I also encourage you to visit the Senior Company's YouTube channel. Both of them have been featured on the podcast so that you can learn a little bit more about estate planning. She touches on a few things a little bit more in depth, I think, as well. And her sister Dahlia has a complete podcast regarding personal injury and some really good tips on do's and don'ts should you find yourself in a motor vehicle accident. I encourage you to visit barkholaw.com as well as theseniornetwork.com for any other resources or questions that you may have in regard to estate planning, personal injury, or anything related to insurance or real estate. We have all of those resources available. So again, this is a recorded webinar. We can absolutely send it to you so that you can review it and see if you have any questions. Just reach out to Donna or Dahlia from the Barkho Law Firm.
Thanks so much, Corey. I appreciate it.
My pleasure. Have a great night, everyone, and thank you again.
Bye-bye, everyone.